Welcome back to the Constitutional Clarion. You may have seen many comments on my videos where people assert that the Commonwealth of Australia has been replaced by a corporation that's registered in the United States, and that having an ABN proves that it's now a corporate business rather than a government. As with many claims, there are kernels of truth behind it, but there are also misunderstandings that cause people to join the dots in ways that don't make legal sense. So in this video, I'm going to explain first what the legal position is so that you can understand what is meant by a legal person or having a legal personality, and the different categories that are involved, including corporations and polities. Later in the video, I'll come to claims about registration in the United States and ABNs and try to sort out the confusion that's been caused. First, let's start with the idea of legal personality. Okay, no, it's not a question about whether or not lawyers actually have a personality. What it means is that every human being is treated as a legal person with the capacity to engage in legal relations and to bear legal rights and duties. Now, what does that mean? I agree, it sounds like gobbledygook. Okay, it means that each person can, for example, enter into contracts. They can own property, they can employ people, they can sue in the courts, and they can be sued. Now, there are obviously some qualifications where people suffer a diminished capacity, such as children, for example, or those who are suffering from a mental incapacity. But all human beings are legal persons. When a group of people join together, this does not necessarily mean that the group itself has a separate legal personality. Say you create a tennis club of friends who like to play tennis. Unless you do more, that club does not exist as a separate legal entity. It cannot own a tennis court or enter into a contract to rent a court out or hold a bank account or employ people to repair the court or be sued if someone is injured due to disrepair of the court. Only the individual members of the club can be held responsible. But you could incorporate your tennis club as an incorporated association if it's a not-for-profit body. This would mean it could, in its own name, accept gifts, buy, own and sell property, have a bank account, invest and borrow money, get insurance and sue and be sued. It would continue to exist as an entity even though its members changed over time. And this is known as perpetual succession. Incorporation also protects the members of the club against personal liability for the debts of the club. If your club was incorporated, it would be subject to laws that deal with incorporated associations in each of the states and territories, and it would have to comply with those requirements, so things about accounting and auditing and reporting. What if you wanted to turn your club into a business that runs for a profit? You could incorporate your club as a company. Now, this makes it subject to many more detailed requirements under the corporations law. There are different types of companies, including companies that are limited by guarantee, where the money that's made by the company stays within the company and is used for its purposes, and proprietary limited companies, which have shareholders and return profits to those shareholders through dividends. Now, that's a fairly simplistic summary, but the bottom line is that individuals have a legal personality, as do incorporated bodies, such as incorporated associations and companies, and collectively I'm going to call them just corporations. They can all enter into certain types of legal relations and bear certain sorts of legal responsibilities, like being sued in a court. But what about governments? Now, this is where it becomes trickier. In countries like Australia, New Zealand, Canada, and the United Kingdom, there is this notion of the Crown, which goes beyond the Netflix series. Now, the term tends to mean different things in different circumstances. So it can, of course, mean the jewelled hat sitting in the Tower of London. It can mean the monarch, both as a person and the office of the sovereign, which they hold. It can mean the political entity, that is the nation or the state, so the Commonwealth of Australia or the state of Queensland. Or it can mean the executive government, as opposed to the other arms of government like the legislature and the courts. To make things even more complicated, historically there was Crown immunity from suit in particular areas, such as negligence. Now, I can't possibly go into all that for this video because, frankly, we'd be here till Christmas, but it would be fair to say that most of the Crown immunity has been diminished over time and you can sue the government in relation to most matters. But who do you sue? Where does the legal personality lie? The Constitution says that it is the Commonwealth that has this legal personality. For example, Section 85 and Section 114 indicate that the Commonwealth can own property. Section 75 of the Constitution refers to suits in which the Commonwealth is a party, and it also allows people to take certain actions against officers of the Commonwealth, which includes ministers. In addition, Section 78 says that Parliament may make laws conferring rights to proceed against the Commonwealth or a state in respect of matters within the limits of judicial power. So we know from the Constitution that the Commonwealth and a state have legal personality because they can own property, they can sue, and they can be sued in a court. But what is their status? Does this mean that they are corporations? Now, there's been quite a lot of argument about this amongst lawyers over time, and much of it is pretty theoretical and obscure. So I'm going to skip, for reasons of sanity, the debate about whether the monarch is a corporation sole and how that relates to governments under the Crown. Instead, I'm going to whiz through to the present. When it comes to the Commonwealth of Australia, the High Court, which is the authoritative body for interpreting the Constitution, concluded in the Williams case in 2012 that the legal personality is held by the Commonwealth of Australia as a polity rather than being held by the executive government. That means that it is the Commonwealth as a whole, being the body politic established by the Commonwealth of Australia Constitution Act 1900, that you sue, not just the government, which of course is only a part of the Commonwealth. The Commonwealth is a polity, it is not a corporation. In addition, parliaments can enact laws that establish certain government bodies separately from that body politic as statutory corporations or companies. The Commonwealth, for example, has by legislation created both corporate Commonwealth entities, such as the Australian Sports Commission, Australia Post, the Civil Aviation Safety Authority and the ABC as examples, and also Commonwealth companies like Snowy Hydro Limited, the NBN Co Limited and the Australian Rail Track Corporation Limited. On this chart, the corporate Commonwealth entities are in green and the Commonwealth companies are in that yellowy colour. Sometimes they are established this way to give them greater autonomy from the government, and in other cases it's because they need to compete with the private sector and behave commercially, or because they're being transitioned to privatisation. The Queensland Parliament once tried to establish a Queensland Rail Authority with all the powers of a legal person, such as being able to employ people and own property and sue and be sued, but it said in the legislation that it was neither part of the body politic of Queensland nor a corporation. The High Court just did not buy that when it was challenged. In the Queensland Rail case, which has an extraordinarily long name, so we're just going to call it that, the majority said that there may be classes of artificial right and duty bearing entities that are bodies politic or that are corporations, but they rejected the idea that a state could make up a new class of bodies that fell into neither category. It was therefore held to be a corporation because it had all the powers of a legal person and it was not part of the body politic of Queensland. You will often see claims on the internet that the Australian government is registered as a privately owned American company or that it's registered as a for-profit corporation in the United States. So is that true? Well, the answer is no. The proof that you are so often shown on social media is that the Commonwealth of Australia is registered with the SEC, that's the Securities Exchange Commission in the United States. Now, first of all, registration with the SEC does not make a body, be it Australian or American or anything else, it doesn't make it a corporation. A body must already have a legal personality of some kind, being a corporation or a polity or something else, before it can register. Second, if you actually read the documents that the people show you on the internet, the Commonwealth of Australia is described there as a registrant, not a corporation, and it's registered as a foreign government in Form 18, and it gives its annual reports under Form 18K, which is for foreign governments and political subdivisions thereof. Any foreign government which wants US investment in government securities has to register there. Now, this does not make it a corporation in Australia or in the United States, nor does it establish shares in Australia or directors of a corporation. If Australia really was a corporation, either formed in Australia or formed in the United States, it would have had to use different forms in order to register with the SEC and do its annual reports. For example, the document you see in those social media posts, which was provided by the Treasury under FOI, was an amendment to its registration statement, which concerned the guarantee that the Commonwealth made in relation to bank deposits in Australia during the global financial crisis. And this is to help inform people who are going to invest in Australian banks. If you read the full document, it refers throughout to the government of the Commonwealth of Australia as guaranteeing those deposits, not any corporation. It also says the Commonwealth of Australia is a sovereign state and that it has not waived any sovereign immunity. Now, this would not be possible if it was an American corporation or an Australian corporation. Now, people keep telling me in the comments section on my videos that the Commonwealth of Australia is listed on the New York Stock Exchange. Really? Well, this suggests that they actually believe that you can buy and sell shares in Australia and that there would be a share price that goes up and down on the New York Stock Exchange. And Alan Kohler would report it on the evening news on the ABC in the finance section. But of course, that doesn't happen, does it? Now, to be diligent, I did do a search of the New York Stock Exchange and all the companies that are registered there, and unsurprisingly, Commonwealth of Australia turns up with 0 results. Now, you can do your own search. Australian government as a term also comes up with 0. If you just put in the word Australia, you get 4 ETFs and an equity fund, none of which are actually the Australian government. Now, finally, we have the confusion about ABNs. Now, ABN stands for Australian Business Number. ABNs were established at the same time as the GST as a way of accounting for GST. Persons and entities that charge GST, whether they are human beings like me, I have an ABN for when I do consultancy work, or whether they are corporations, or whether they are government entities, need to have an ABN, unless they fall under an exemption because they have a very small turnover. Having an ABN does not in any way affect their existing status. As was stated by the Western Australian Supreme Court in Williamson and Hodgson in 2010, quote, "A person or entity does not become a corporation because that person or entity has an ABN. An ABN is required for any organisation or individual who carries on an enterprise with a GST turnover above a certain sum. Further, anyone who wishes to claim GST credits or fuel tax credits needs an ABN. An ABN holder may be an individual, a corporation, a partnership, or a government entity. It is not necessary that the entity be engaged in a profit-making venture, unquote. These arguments about the Australian government being a corporation or about bodies that hold ABNs somehow becoming illegitimate have been made umpteen times in the courts by people who no doubt sincerely believe them. And they've also been rejected umpteen times by the courts because they have no legal basis. As Justice Tottle in the Western Australian Supreme Court said in Corica and the Shire of Mundering in 2016, it is unfortunate that some litigants in this court, and especially self-represented persons, continue to be seduced by these arguments and to run the risk of cost orders being made against them by repeating the arguments in litigation when they are doomed to failure. Yes, it is sad. These sorts of myths circulated on the internet do have real-world consequences, with people potentially suffering greatly if they have costs awarded against them, maybe even lose their home. So do be careful about who you believe, and when you do your research, actually read the original documents. Don't just listen to what someone tells you on the internet, especially when they don't have any qualifications. And if it does become an important matter, do get proper legal advice, because it could save you a fortune, and that's your fortune, so it's important. Thank you for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.